G'day, fugitive Australian journalist Shane Dowling from the website kangaroocourtofaustralia.com. Now, the ACT inquiry into the police cover-up of the alleged rape of Brittany Higgins by Bruce Lehrmann is going to start public hearings on Monday, the 1st of May, which is next Monday. And I'm about to show you the first 20-odd minutes of the opening day, which is on the 17th of April. And they outline exactly what the inquiry is going to investigate and what findings they're meant to hand down at the end of the inquiry. And also obviously the contact details of the inquiry if you want to go to their website, look at the live stream or all the submissions that have been published, etc. So it's well worth watching if you're going to be following the inquiry in any shape or form. And the first 20 minutes outlines exactly how the inquiry came about, the complaint by the Director of Public Prosecutions, the letter he sent, and also Bruce Lehrmann's made a complaint against the Director of Public Prosecutions. They're going to look at that as well. And also the Victims of Crime Commissioner, how she showed up with Brittany Higgins. That's a bit of a minor side issue, but she had the title of Victims of Crimes Commissioner, and that sort of gave the inference that Bruce Lehrmann was already guilty when sort of the media were reporting that it was Victims of Crimes Commissioner showing up with Brittany Higgins to the trial. So it's a bit of a side issue, and maybe she should change the title of a job so that presumption of innocence is still there for everyone who is accused of a crime, and she can show up. And Aaron Longbottom KC is a counsel assisting the inquiry, and she'll outline all those details now, and I'll show you the video.
On 1 November 2022, in the immediate aftermath of the vacation of the trial, the Director of Public Prosecutions, Mr. Shane Drumgold, wrote to the ACT Chief of Police alleging over 1.5 years of consistent and inappropriate interference by police investigators in the proceeding and calling for a public inquiry. In that letter, Mr. Drumgold contended, amongst other matters, that at a meeting in relation to the proceeding, police cherry-picked elements of potential evidence advanced as constituting weaknesses in the case, that in a request for advice from the
Ms. Longbottom.
Mr. Sofronoff, I appear with Mr. Jones.
Thank you.
I understand that there are other parties that wish to apply for leave to appear.
Yes.
May it please the inquiry. My name is Tedeschi. I appear for Mr. Shane Drumgold, the DPP of the Australian Capital Territory, and I'm assisted by Junior Counsel, Ms. Annewell, and we are instructed by Mr. Ian Denham of Moray and Agnew.
Thank you, Mr. Tedeschi.
Please inquiry. My name is Webster. I seek leave to appear for Ms. Jerome.
Thank you, Ms. Webster.
May it please the inquiry, my name's Edwardson and I seek leave to appear on behalf of Mr. Stephen Wybrow on the instructions of Mr. James Berg.
Thank you, Mr. Edwardson.
May it please the inquiry. My name's Mitchell. Ms. Richardson appears for the AFP and I appear with her and we seek leave to appear.
Thank you, Mr. Mitchell.
May it please the inquiry. My name is Dwyer. I seek leave to appear for Ms. Heidi Yates, the ACT Victims of Crime Commissioner, instructed by Ms. Evans of Earthly Webster and Evans.
Thank you, Ms. Dwyer.
Thank you. My name is Ganek. I seek leave to appear on behalf of the 13 AFP police officers as per my written application.
Thank you, Mr. Gneck. So just to tidy up, in case anybody hasn't been given leave to appear, each of you is given leave to appear. Yes, Ms. Longbottom.
On 1 November 2022, in the immediate aftermath of the vacation of the trial, the Director of Public Prosecutions, Mr. Shane Drumgold, wrote to the ACT Chief of Police alleging over 1.5 years of consistent and inappropriate interference by police investigators in the proceeding and calling for a public inquiry. In that letter, Mr. Drumgold contended, amongst other matters, that at a meeting in relation to the proceeding, police cherry-picked elements of potential evidence advanced as constituting weaknesses in the case, that in a request for advice from the DPP, police provided blatant misrepresentations of evidence and made an overt attempt to apply pressure to the conclusion of that advice, and that during the conduct of the trial, a number of disturbing events occurred, including constant, exclusive, direct engagement of police with the defence rather than the prosecution. Mr Drumgold called upon Commissioner Gagan to issue a direction to all police to remove themselves from any engagement in the matter beyond being called as witnesses for the prosecution, including no further contact with defence or other prosecution witnesses, no contact with the complainant, and prohibiting police attendance at court beyond formal evidence if required. The ACT Chief of Police, Commissioner Gagan, welcomed that public inquiry, but asked that it consider all aspects of the matter, including the actions of police, the prosecution and defence, issues leading to delays in the trial, issues leading to the subsequent mistrial, and the decision of the DPP not to proceed. Mr Sofronoff, the ACT government has asked you to consider the actions of police officers, the Director of Public Prosecutions and the Victim of Crime Commissioner in the criminal proceedings. It is important to emphasise that this is not an inquiry into the allegations made by Ms Higgins against Mr Lehrmann. It is only concerned with the way in which each of the criminal justice agencies involved fulfilled their duties in the investigation and prosecution of those allegations, as well as in the course of providing support to Ms Higgins in that proceeding. The police investigation and criminal prosecution drew intense media and public interest. That was in part because the alleged offence occurred at Parliament House. But those events were also taking place at the time of intense public discussion about sexual violence against women in light of the Me Too movement, and specifically in the ACT, media reports of low rates of sexual assault trials and convictions, despite increases in reports to victim services and police. That context seemingly affected police charged with the responsibility of investigating the allegations made against Mr Lehrmann, as well as the DPP and the Victims of Crime Commissioner, who had the statutory function of providing Ms Higgins with support. That context also brought into question the threshold for charging and continuing the prosecution of an allegation of sexual intercourse without consent, and the significance of the credit of the complainant in those decisions. Public confidence in the criminal justice system is essential to the maintenance of democracy. The public expects police officers to exercise their considerable power to investigate crime and charge people with offences strictly in accordance with their duties. The public expects that prosecutors will act impartially in accordance with their obligations to uphold the right to a fair trial. A collaborative working relationship between those charged with a duty to investigate crime and those charged with a duty to prosecute crime is essential to any well-functioning criminal justice system. The relevant duties have been imposed in order to ensure that a trial is a fair trial. Fairness should not, however, be confused with weakness. Any fair criminal justice system also ensures that everything is done that lawfully and ethically can be done to secure the conviction of a guilty accused while ensuring the acquittal of an innocent one. And of course, a criminal justice system that is fair respects the rights of those involved and will attract the public's confidence. To that end, the ACT government has called upon you to examine its framework for progressing criminal investigations and prosecutions to determine whether in this particular case it functions with integrity. I turn to your terms of reference. Insofar as the ACT police are concerned, You are tasked with investigating whether any police officer failed to act in accordance with their duties or acted in breach of their duties in 4 respects. First, in their conduct of the investigation of the allegations by Ms. Brittany Higgins concerning Mr. Bruce Lehrmann. Second, in their dealing with the DPP in relation to his duty to decide whether to commence, continue, or discontinue criminal proceedings against Mr. Lehrmann. Third, in their dealings with the legal representatives of Mr. Lehrmann before, during, or after the trial. And fourth, in their provision of information to any person in relation to the matter. If you discover that any police officer did fail to act in accordance with their duties or acted in breach of their duties in respect of the matters that I've just outlined, you are required to investigate their reasons and motives. Police services are provided in the ACT by a business unit within the Australian Federal Police known as ACT Police. That is pursuant to what is called a policing arrangement between the Commonwealth Minister for Justice and the ACT Minister for Police and Emergency Services. Under that police arrangement, the ACT government is required to purchase police services from the AFP. In this case, the investigation of the allegations against Mr. Lehrmann were undertaken by officers in the Sexual Assault and Child Abuse team of ACT Policing, that is otherwise known as SACAT. The conduct of that investigation was in 2 stages. The first stage began around the 1st of April 2019 when Ms. Higgins made a complaint to the Australian Federal Police stationed at Parliament House. This included what is described as a meet and greet with ACT Police, during which there was a discussion with Ms. Higgins about the role of various agencies that would be involved in the investigation, as well as about the interview, investigation, and court processes. That first stage of the investigation came to an end when Ms. Higgins emailed the ACT Police on the 13th of April, advising that she did not wish to proceed at that time. The second stage of the investigation began in February of 2021. On the 5th of February, Ms. Higgins contacted ACT Police and asked for her complaint to be reactivated. On the 6th of February, investigators from SACAT met with Ms. Higgins and informed her that the investigation would not recommence until she provided a formal statement in the form of an evidence-in-chief interview. That took place on the 24th of February, and after a recorded interview between Ms. Higgins and Lisa Wilkinson was broadcast on the Network 10 program called The Project. From the early stages of the recommenced investigation, SACAT police officers met with members of the Office of the Department of Public Prosecutions regarding the matter. That is not unusual. In fact, the need for regular communications and discussions between those 2 agencies is formally recognised in a collaborative agreement that they entered into in 2019. But you will hear evidence that from the outset, engagement between the DPP and ACT policing in this matter was beset by tension. Those involved in the meetings appear to have somewhat different perceptions of what occurred, but in broad terms, the points of conflict included the following: whether it was proper for ACT policing to conduct a second evidence-in-chief interview with Ms. Higgins, as they did on the 26th of May 2021, confusion about whether Mr. Lehrmann should be charged and how matters affecting the credibility of Ms. Higgins were to be treated by police when deciding whether to charge Mr. Lehrmann, and by the DPP when deciding whether to present an indictment. The delivery of the brief of evidence to lawyers for Mr. Lehrmann once he was charged on the 6th of August 2021, but before he entered a plea. That brief included counselling notes that were prohibited from disclosure without the court's leave, and this led to some controversy. And the apparent close engagement between investigating officers and the lawyers for Mr. Lehrmann during the trial, which led to some distrust between police and the DPP. You will be required to consider the testimony about those matters and determine whether ACT police officers failed to act in accordance with or breached their duties. As part of your consideration of those issues, you will hear evidence from officers about their training and police procedures regarding the investigation of sexual offences, evidence of confidential interviews conducted with ACT police not involved in this particular investigation about their training, policies and procedures, as well as underlying cultural reviews with respect to the investigation of sexual offences will also be tendered. To the extent to which your inquiry may reveal deficiencies in ACT police training, policies and procedures regarding the investigation of sexual offences, many of those issues are already currently being considered by the Sexual Assault Police Review that is co-chaired by Dr. Christine Nixon and Ms. Karen Fryer. This inquiry will not unnecessarily duplicate the work that has already been undertaken by that body. You are also required under your terms of reference to investigate whether the ACT DPP failed to act in accordance with his duties or acted in breach of his duties in making his decision to commence, to continue, and to discontinue criminal proceedings against Mr. Lehrmann. If the DPP so acted, you are to discover his reasons and motives for his actions. The functions of the DPP include, in relation to indictable offences, conducting proceedings on indictment, whether instituted by the director or not. An aspect of that function is deciding to continue or discontinue proceedings commenced by charge, as was the case here. The decision to prosecute is discretionary and of its nature insusceptible to judicial review. That is because the integrity of the judicial process, particularly its independence and impartiality and the public perception thereof, would be compromised if the courts were to decide or were to be in any way concerned with decisions as to who is to be prosecuted and for what. As such, there can be no adjudication of whether a prosecutor's assessment of a particular case is right. There is not much guidance in the case law. But following the establishment of an independent DPP office in each jurisdiction in Australia, directors collaborated to prepare uniform guidelines identifying a two-stage test for the decision to prosecute. That test, as currently stated in the ACT prosecution policy, requires consideration of whether the evidence offers reasonable prospects of conviction and, if so, whether it is in the public interest to proceed with a prosecution. You are required to examine the DPP's consideration of that two-stage test at material junctures in this matter. That includes when the DPP was asked by ACT Police to provide advice in June of 2021, when he presented the indictment against Mr. Lehrmann on the 9th of November 2021, when the trial was vacated on the 27th of October 2021, and when the DPP decided to discontinue the proceedings on the 1st of December 2022. Information and statements from witnesses have also raised issues about the DPP's conduct of the case, both before as well as during the trial. Those issues include the steps taken by Mr. Drumgold in response to the inclusion of the counselling notes in the defence brief, and the decision made by the DPP not to disclose information provided by Ms. Fiona Brown, the former Chief of Staff at Senator Reynolds' office, after she had given evidence. On the 1st of November 2022, before the matter was discontinued, the DPP wrote the letter to the Chief Police Officer that I referred to at the outset. In December of that year, the letter was released under a Freedom of Information request and subsequently published in the media. You are required to inquire into the circumstances of the public release of that letter by the DPP. The final aspect of your terms of reference require you to consider whether the Victims of Crime Commissioner acted in accordance with the relevant statutory framework in terms of support provided to the complainant in the matter of the Crown and Lehrmann. The Victims of Crime Commissioner holds several functions under the Victims of Crime Act 1994 in connection with the administration of justice. Those functions include advocating for the interests of victims, ensuring the provision of efficient and effective services for victims, and encouraging and facilitating cooperation between agencies involved in the administration of justice with respect to victims. For the exercise of the Commissioner's functions under the Act, she is entitled to be present at the hearing of a proceeding in a court in respect of an offence. The intersection between the Victim of Crime Commissioner's statutory functions in respect of victims, which the Act defines to include a person who suffers harm because of an offence, and the criminal justice process, the central plank of which is the presumption of innocence of the accused, provides the context in which you are to examine her actions in this matter. Ms. Heidi Yates is the Victims of Crime Commissioner. You will hear evidence that in the early part of 2021, Ms. Yates began assisting Ms. Higgins in her role as Victims of Crime Commissioner, and that included acting as an intermediary between Ms. Higgins and the ACT Police investigating the matter, as well as the Office of the Department of Public Prosecutions. Mr. Sofronoff, before I conclude, may I outline some administrative information regarding the inquiry? The board has a website. Mr. Romero, would you please bring that website up? It is located at www.cjsinquiry.act.gov.au. There, one will find over time the evidence collected and relied upon by the board, submissions from the public, transcripts from the hearings, and the live stream to watch during the hearings. Since the announcement of this inquiry, you have issued 33 statement requests and collected over 143,000 documents. Those statements will come from central figures involved in the investigation and prosecution of this matter, including SACAT investigating officers, the DPP and other lawyers within his office, as well as the barrister for the defendant, Mr. Stephen Wybrow SC. It is the plan that the board will conduct up to 4 weeks of public hearings, and those public hearings we now anticipate will commence on the 1st of May this year. Every effort will be made to publish the day's exhibits and transcripts each evening. There may on occasion be a delay because of the care to ensure that evidence the subject of a non-publication order is not released, but the public and media can be assured that every effort will be made to give them access to the evidence as soon as is reasonably practicable. After the hearings, affected parties will be given a list of potential adverse findings and will be invited to make a submission as to whether or not you ought to make such findings. That is all we wish to say at this point, Mr. Sofronoff. Thank you.
I'll be publishing an article on my website, Kangaroo Court of Australia, on Thursday, the 27th of April. So make sure you visit my website because the article will have further information. You'll be able to click on the links to the inquiry's website, etc. And Kangaroo Court of Australia is independent media. I publish a YouTube channel, website, Facebook page and Twitter account, and I'm reliant on donations to keep on publishing. So please make a donation to my Patreon account or PayPal account. It all helps out. And please share this video on Facebook or Twitter, etc. Thank you for your time and have a good day.